Hi everyone, it's Grant Abbott speaking, and welcome to another one of our Lightyear training group, and Abbott-Family training webinars. This one is, as you can see, it's going to be advanced pension estate planning strategies. I'm assuming here there's a lot of knowledge there that you already have in being able to do basic TRISs, understanding the transfer pension balance, or the T-bar, understanding what an account-based pension is. And then what I want to do from that is start to really give you a good understanding of where we've come from in terms of pensions, more importantly, where we're going to, where it fits in that whole asset protection space, which is absolutely crucial. And also, I'm going to build a couple of pensions there for you, particularly for blended families, etc. So the concept of the original pension, and when I start talking about an auto reversionary pension, it would be, for example, it goes from a Grant to my wife Amanda, and then I can then go from my wife Amanda to my daughters from my earlier marriage. So I can start to do this pass the parcel, pass the baton of these pensions. And that's not unheard of. I mean, it's been going around for a long time. Many years ago, if you have a look here, the first ever pension, and the difference we have a look at is an income stream has been around for a long, long time. In 2500 BC, they were first recorded in Egypt. So essentially, give a lump sum to someone. I might give you a lump sum of $100,000. Then over the next 5 years, you might give me, $21,000. So there's an inherent interest rate in there, but I'm getting that consistent income stream over a period of time. So when we have a look at that if we did that over 5 years, that's a 5-year term certain, because I know what the term is, income stream. And it's got what we call a zero residual capital value. That is, you're getting 5 payments of $21,000. That last payment then terminates that contract. Alternatively, I could do, for example, a 5-year 100% residual capital value. So you give me $100,000, and then I'll promise to pay you back $1,500 per annum, because it's got the underlying inherent interest rates to it. And then in that last payment, so I made 5 payments of $1,500, and then the last payment is the $1,500 plus the original capital back. So that's 100% RCV, or residual capital value. Alternatively, I can adjust it, so it could be 50% RCV, it could be whatever. So it doesn't make any difference. And now, if I did a 100-year annuity, then effectively that would pass on for many generations. So I now need to start to look at succession planning in terms of my pension. And for those of you who've been through me in the course, the PEPPA course, and just on that side, we're currently we've been held up in terms of getting bank accounts for PEPPA, mainly because we've got 6 directors residing primarily in both Melbourne and also Sydney. So it's very hard to get their signatures on bank accounts. But once that's done, we'll be launching the site, and then we'll be doing a full formal launch of PEPPA. And then that will include all our members, our foundation members. And also, for those of you who've done that 3-day course and you've successfully accredited a certification as specialist succession asset protection estate planning advisors, or PEPPA advisors. So that's going to be really exciting. But one of the key features there is, again, succession, asset protection, and estate planning. So those are the 3 criteria that in my mind these days is we need to load any transaction or undertaking against. So for example, if I set up a company, how does that go in terms of succession, asset protection, and also estate planning? Estate planning, it can be good, but it can also be ugly. In terms of succession, for those of you who've probably been utilizing our systems, where a sole director of a company dies, that jeopardizes the undergoing realities and economics and business and investment potential of that company. If it's a trustee of a family trust or an SMSF, it's even worse. So we've come up with that successor director solution that helps in terms of that success. If someone dies, there's a succession plan in it. There's built-in estate planning, and there's also asset protection. So when we have a look at all of those, we should bear that in mind. And again, with that annuity, as I said before, we've got a position there that annuity can go for 100 years. With pensions, and so the difference between the two forms is an annuity is where someone gives a lump sum and then receives an income stream for a period of time, which is a term certain for life. So you'll see that many of the large life insurance companies, AMP, Challenger, offer lifetime annuities that then have perhaps a reversionary to the spouse. So it goes for the life of the holder, then the spouse as well. Now, when we talk about superannuation funds, the term annuity then splits into the word pension. So we don't necessarily have annuities under Australian law. Annuities are only able to be offered by life insurance companies and also building societies, etc., and also associations like IOOF. Whereas when we're dealing with pensions, they come from superannuation funds. So really they're interchangeable, same body of law. And as you can see, the body of law has been around since 2,500 BC. So what we need to do now is we need to now start to really open our minds as to what is possible. So Mitch, a really good question. If you have gone through, we've drafted up a PEPPA logo that you'll be able to put on your cards. So I would estimate we're looking at the end of September. Just hold off on that one. So what we need to do now is really immerse ourselves and get away from just the basic account-based pensions that we've been doing, because most of the pensions you draft are no good for succession, no good for asset protection, no good for estate planning. In fact, they're probably not very good for tax either. So really all those key criteria you can throw out the door. Whereas if we do a really good strategy, so for example, let's say that we've got John Smith. John Smith is age 70, he's taken a pension, he's about to commence a pension. So what we're going to do is build a pension for him. We're able to build those pensions. So if he wants an income stream, we can then elicit from him the terms and conditions around the income stream, what sort of income stream he wants. If you're a tax agent or an accountant, you can go out and you can effectively do that under those asset guidelines. So we can move monies from the accumulation side, which is that payment of the lump sum, to the pension side. So effectively, what you're doing is you're using your superannuation accumulation to create a pension. So if I just get, for example, $500,000 that's sitting in the accumulation stage, John Smith's age 70, he wants to take an income stream, then effectively what we do is we take that $500,000 from the accumulation, we draft up pension documents, and then it goes to John Smith. So it sounds okay. I mean, that's generally probably around about 99% of pensions. And in fact, at this present point in time, there's around about, I think, $250 billion in pensions being paid from self-managed super funds. So it's a pretty big ticket item. So let's just go and have a look. So we've got John there. He's age 70. We've got $500,000. So we know it's an account-based pension. So he's got a minimum income stream. He's got his wife, Sally, who's age 52. So it's his second marriage. And then he's got a couple of children from his first marriage. They're both age 40. And then he's got grandchildren from those children who are in their 20s. So he's got there's a big net of people to focus in on. So let's just have a look at the first stage. So John Smith, $500,000, pension started, tax-free income stream. He's obviously got no problems about T-bar, so we transfer it over. Remember, we've paid the accumulation amount to then acquire that account-based pension offered by the trustee of the fund. What happens from there is then John dies at age 71. So it's been going for a while. His income stream is, his account balance is still worth $500,000. Income has been paid up to the date of his death, which is required. And then there's still $500,000 because obviously the amount that's paid out is the same amount that's been earned on that pension income, less obviously expenses. So what happens to that $500,000? Well, if the pension that we've written has no auto reversionary, so just stops when John stops, then that $500,000 moves from the pension side back to the accumulation side because the pension stopped. And there's quite a significant ruling from the Commissioner of Taxation on that. If you do a cessation, then there's a commutation. If you do a full commutation, and a commutation is converting, remember we go from lump sum to income stream. To go from income stream back to lump sum is called a commutation. So that process of turning an income stream into lump sum is called a commutation. So what we do is if John dies and there's no auto reversionary, then it goes back to the accumulation stage. And so effectively what happens, we're off and running there. From that perspective is that then John's spouse, depending on what, there obviously there's no reversionary. So we're going to depend on what happens in the SMSF will or the binding death benefit nomination as to what happens to his $500,000. His spouse, Sally, could commence an income stream if that's what was built into the BDBN. So that's then, she can do that, and then that's tested against, within a year, it's going to be tested against her pension T-bar, which is fine. And from her perspective, she'll be starting that pension and then essentially will be off and running. So it's going to depend, as she's only 50 years of age, she'll be able to start the pension because it's unrestricted, non-preserved, but it's going to be accessible to her with a 15% tax offset. So that's fine. The alternative would have been to go from John then directly to Sally. So if I go from John to Sally, because John was tax-free, Sally just continues. So what happens, and this is the way for accountants to record it. So once you receive the death certificate for John, you just close out John's pension account and automatically transfer that pension to a separate pension for Sally. So the good thing about it is the way the tax system works is that now automatically transfers to Sally. Sally picks up the same tax profile as John. Because it was tax-free to John, it's going to be tax-free to Sally. Even though she's 50, it's still going to be tax-free to her. Does that make sense? So we're in a good position there for Sally. But if John wants to leave something over for his adult children, then we're in a bit of a pickle because it can go John to Sally, and then Sally could then just commute it all, or she can spend all the income stream, and that means that there's nothing left over for the children. Now, you can borrow from those of you who have done a lot of estate planning. If you think about the concept that in a will that John might have a house, Sally then has a life interest in that house, meaning she can continue to stay there with terms and conditions attached because it's effectively a life interest trust up until the day that she dies. Likewise, it can be the same. So, for example, if he wants to leave something over for the children, it could go John to Sally, and I'm going to build this for you a little bit later on. So, as I said, this is advanced. I'm dropping it right in the deep end, and then we'll pull it back and then we'll go through it. So it goes John to Sally, but then the remainder goes to the children. So it goes John, Sally, the children. Now, the children under SIS law effectively are dependents. They're not financially dependent at that time, but they're certainly dependents. All children are dependents. Now, what will happen is it go John to Sally, then to the children. Now, the issue about it for the children essentially is that if they're over age 18 and not financially dependent, then they can't take the income stream. So there's a forced commutation. So it goes John, Sally, let's say to the two children. Then those two children then can, if they want to take it, they can then take that lump sum directly out of the superannuation fund. When they take it out of that superannuation fund, they can obviously just utilise it They may be up for 17% tax on the taxable component unless we can show that we are financially dependent upon, or they were financially dependent upon John at the time of his death. And then at that stage, then they would also get the 0% tax profile, but they can't do it. Alternatively, it could go, and I just want to stretch your mind here, it could go from John to Sally, and then let's say one of the children's names is Max, and Max has got two children, William and Bob, so Billy and Bob. So it could go from John to Sally and then to Billy and Bob. Now, Billy and Bob are both under age 18. So effectively, we've got a position there that that income stream could be used for Billy and Bob. Now, the good thing for Max is the guardian. So he's going to get this income stream for Billy and Bob, going to be in control, use it to pay education expenses, pay staff, even pay to himself, pay board to himself for looking after Billy and Bob. The important thing about that is that the same tax profiles that's going to John, Sally, and then Billy and Bob, if they receive it, their grandchildren, it'd also be tax-free to them for as long as they hold it. So how long can that income stream last now that's going to Billy and Bob? They're both 18. Well, effectively, till it runs out or till the last one dies. If they're receiving it jointly, then if one of them dies, it goes over to the other one. So if Billy's dead, then it automatically goes over to Bob. So we can have these income streams joint. So we're now starting to look at these pensions from superannuation funds that really are using the same tools that we have with annuities. So they're long scale things. And I want to come back and I'll show you how to build it a little bit later on, but I want to get your mind around those concepts as well. So it's pretty important. So I'll just take a couple of questions and then what we'll do is we'll go back. So from John, what happens to the tax on an SMSF where a pensioner receives an annual pension payment, but he dies in the financial year before the pension payment is due that year? So that's a really good question, John. In order for the pension to be complying and then do whatever we want, what happens, a minimum pension has to be paid. So that what will happen is the trustee of the fund, because when we have that pension, there's a couple of ways of doing it. It's really important, John, this question. And I want you all to listen to this because this is really crucial. Inside your trustee, which is your governing rules of the fund. So the governing rules of the fund include obviously the trustee, and when you do a pension document, that becomes part of the governing rules of the fund. Now, the governing rules of the fund are really important. One is it means that we as advisors are the auditor to the fund, the trustee to the fund, the financial planner to the fund, the lawyer to the fund, anyone to the fund must abide by those rules. A failure to do so means that the recipient of the pension, if they've lost out or there's been damages as a consequence of the failure of any of these people to abide by the governing laws or the governing rules of that pension, effectively they may sue for loss or damages under Section 218 or Section 55(3) and recover those. And they're strict liability offences. So it's got nothing to do with negligence. It's just simply if I as a lawyer can prove that you've created a damage to my client, then effectively that'll be it. So, and I'll talk about that a little bit later on. So that's really important. The second one is also that if there's been a case where there's been a damage or there's been a breach of the governing rules, then effectively, if someone's profited off of that, then in short, we can go and contact the ATO and seek a criminal prosecution against that person. Because if they've undertaken it by way of fraud, then potentially there's a 5-year jail term. And likewise, anyone who's aided or abetted that person is also caught under the Commonwealth Crime Act for the similar sort of imprisonment or the offence. So this concept of the governing rules is absolutely crucial. And I just want to come back to what John is saying. So we need to have a look at our deed and find out when membership ceases. So 99% of the deeds that I review, once a person dies, that's it, their membership ceases, which is fine. So that's A-OK. Now, on that one, so if I have a look at it, let's go back to John. We haven't done any reversion. So remember John, the original one, the $500,000, he starts up a pension, there's no reversion, he then dies. If that deed says that his membership ceased, then that $500,000 balance at that time that he dies must be put into a holding account. So effectively that then has to be looked after if it goes out to his spouse or children or goes to the estate, it's going to go out to those people. But it can only be that amount up to the time of his death. Any amount, so it might take, let's say, a year, goes out, and then we find that we're ready to pay out $500,000. Any income that's been earned on that amount can't be paid out because his membership ceased at the time of his death because of those governing rules. Does that make sense? Completely differently, if you go and have a look at the definition of membership in the Lightyear Docs deed, and we looked at this in terms of the PEPPA course. And for those of you who haven't done that, there's another one coming up at the end of October, which will be exciting, but we just need to get all our cohort through at this present point in time and get them certified. In that instance, what will happen is we've got a position that that membership, if you have a look, continues on in the name of the legal personal representative. So, for example, executor. So the pension, the membership doesn't cease. In fact, that income stream continues on until those benefits are paid out. So that's a beautiful thing because it means, remember we talked about the pension stopping and going back to accumulation, simply by putting those rules and terms within our deed enables it to continue on and still retain that tax exempt status. Because remember, when it goes back, there's a whole lot of stuff that's going on there. So going back to what John is saying is the trustee of the fund must make a minimum pension payment for the year. So if the client dies, if John dies, then that minimum pension payment, if John's not around, needs to go to the executor. That has to go, otherwise it's not, the fund's obviously got serious compliance issues. So that's a really good question there, John, and thank you for that one. Drew, what is the criterion for financial dependence? How substantive an amount does it need to be to have that concept accepted by the ATO? That's a really good issue, Drew. And currently, Abbott-Morley, we've got a private binding ruling that's going in. If you go in and have a look at the not that you haven't got much to do, because I know you're really busy, but from a legal perspective, Drew, if you go in and have a look at the legal side of the ATO website, where they keep all their precedents, their private binding rulings, there's a huge plethora there in relation to financial dependence. Obviously, it's the biggest tax game in town. As more and more of our clients die, that taxable component effectively is going to be taxed at 17%. We saw one recently that we're now making a private binding ruling on $1 million money going out. There was $170,000 tax that was withheld. And it doesn't matter whether it's SMSF or retail or industry. This was a industry superannuation fund. They took out $170,000 tax. So now our position is to argue that effectively they were financially dependent. I've had a look at the case, etc. And to me, there's quite a really good, strong case of financial dependence. But it's interesting, I spend a lot of time, because I haven't got much of a life. My wife works too hard, I'm up early, and I love doing all your queries. There's a really good private binding rulings that you don't need that much in order to prove that financial dependence. Essentially, you don't have to have wholly, it's not 50% or whatever. In Malik's case, the commissioner said you have to prove 50% of your income comes from financial dependence, and the tribunal held that was not the case, and they used a whole lot of cases because this financial dependence issue, Drew, really goes back to workers' compensation, because it's not specifically defined in the SIS Act or the Tax Act. We have to refer to the common law or other laws. And in the Workers' Compensation Act, way back to the 20th century, there's a whole plethora of cases, because under workers' comp, an amount could only be paid out to financial dependents. So you can imagine there's a big body of law there. So you just have to show partial financial dependency. The quantum, feel free to jump onto our support ticket and say, look, I've got a client here, here, and here. What should I do? And then what we can do is we can have a look at it. Importantly, remember that family allowance agreement that's sitting in the Lightyear Doc site. That's an important tool, because what we do there is, remember, we might have, for example, John, and remember his son, Max, and his two grandchildren, Billy and Bob. If John makes a continuous monthly payment, which seems to be the strongest feature of showing financial dependent, a continuous monthly ongoing support that enhances their lifestyle, then it would mean that if it's attached or it's driven to the whole family. So if I just did an allowance to Max, then it's only going to be Max who potentially might be a financial dependent. But if I do the family, then potentially all of the family may be financial dependent. Hence, I can then pay an income stream if at the time of the death of John, both Billy and Bob were financially dependent upon John, then they can be in receipt of that income stream. So that's a really important one. And I'll show you how that works a little bit later on. If you've got something that, again, what I would be doing, if you've got a family allowance agreement or anything like that, or any client that dies, have a really good investigation of what's going on around the family, who's getting the money, etc. And then if you can get that tax back, absolutely get that tax back by showing dependence or doing a private binding ruling. And again, at Abbott-Family, we're more than happy to help you there. George, does paying the pension to Billy and Bob mean that Max has to be financially dependent, or Billy and Bob? So again, I think I just answered that, George. So there's two questions there. So I need to break it apart. So the first question is, in order to, if we're building that pension for them, I'm going to build one. So George, it goes from John, and then it goes to Sally. But let's forget about Sally. Let's say it's just going to go to John, instead of going to Max, the son, because Max, even though Max may be the son, the pension rules only allow, because he's over age 25 and no longer financially dependent, unless he's a disabled child, he has to take as a lump sum. So instead, we might say, okay, it goes from John and then goes to Billy and also Bob. So if it goes to Billy and Bob, then in those circumstances, what we've got there is, if it was tax-free to John, then it's also tax-free to Billy and Bob, which is crucial. So that's important. From an asset protection point of view, it's not the best for Billy and Bob, because it is actually their property. The same with matrimonial property as well. So we just have to be careful about that, to consider, is that the best thing to do, or should we just take it through into, for example, SMSF Death Benefits Trust? From John Stitt, the original deed was McPherson Fund deed from September 2003, which would be pretty ugly. After his death, we've now replaced the deed with the LYD deed and put a second individual trustee. The trustees are now the wife and the sister. Well, in that instance, then you're going to be right. So that pension will continue. Now, if you have got, and I'll show you a little bit later on, but if you've got an existing pension and you want to put a reversion over it, then you'll have to upgrade the deed to ours, because we've got a mechanism in there to enable adding a reversion on top of existing pension. So again, that's a really good strategy to do there, rather than just simply forcing it back to the accumulation side and being dealt with accumulation. I prefer reversions, because the thing is, if I've got a reversion, if you think about a family provisions claim is someone, child, spouse, ex-spouse, even friend, if they can show that you've looked after them financially, they can make a family provisions claim. And as a consequence of that, there's a claim against the estate. In New South Wales, they have the notional estate, which may include superannuation, but certainly doesn't include a pension. So again, from a family provisions protection, a reversionary pension is the best by far. Chris Foster, would the provision of a tax-free loan funding a house purchase be deemed to be financial dependence? I would say from that one, Chris, that it's probably worthwhile. I'm just thinking on the spot as the best way of doing it, because what we want to do is Chris, we want to make something really like super secure. So when I go to the tax office, because they're going to want the money, but for the most part, it actually seems that they're being very generous and giving back to the estate. But I have to show my bona fides. So I would probably, if you are doing a tax-free loan to a child or whatever, I probably would put interest rate on it, but built within that loan agreement that at any point in time, the lender can then gift or forgive that amount. So that forgiveness of that, particularly if it's on a regular basis, like a quarterly basis, that would amount to financial dependence. So that's a really good question though, Chris, and that's why I love doing these sort of sessions of getting fantastic questions. Is there a minimum, Daisy, you've always come up with some fantastic questions. Is there a minimum or reasonable amount that would be regarded as regular payment, phone bills? If you have a look in Fall's case, it was around about $200 a month was the case there. So again, I've in fact seen instances where the old Super Complaints Tribunal, which has now been absorbed into the superannuation division of AFCA, where simply a couple holding joint bank accounts were held to be financially dependent. So, you know, the bar that we originally had a look at many years ago, when I started first talking about financial dependence, now seems to be getting lower and lower. And how do I know that? Because I read the Commissioner's rulings. For those of you who did the course, you'll actually see that private binding ruling on dependence in the estate planning section in the resources in your course. So remember, you can access that course forever and a day. So go and have a look at that, because that's really instructive. Interest-free loan, again, Chris, what I was saying there is that, again, with I suppose you're still always going to have that if you could put interest in there and forgive it, I just think it's going to be a little bit stronger. Now, let's move on, because I want to get into, obviously, building for you. So we've got here an income stream, whether a pension or a transitional retirement income stream of financial products. They are licensed products, but again, have a look at the ASIC guideline on that one, Info 216, and that will talk about, that shows exactly what you can do in terms of income streams. So you're able to tell them about the tax consequences of the income stream by adding reversionaries, the tax consequence of each of those. So again, the whole idea is to give the client a focus about all the options. And I've already showed you what all the options are. Just be careful when you are writing an SMSF will. I know a number of lawyers prefer to have everything done by way of a binding death benefit nomination rather than a reversionary pension. I always put, you'll see when you do an SMSF will, whether you've got the ability within there, as one of the 6 key features of doing an SMSF will under eyesight, is whether to effectively have the SMSF will override the pension. Because of that family provisions protection, I always say no. I prefer, if you've done an auto reversionary pension, just leave it as it is. It's got the best. The only time it would change would potentially be if it goes to Billy and Bob, and obviously we're concerned about bankruptcy, etc. So what I would suggest around that one is, again, as we're building these sort of things, it's a hugely relevant estate planning tool. As I said, we may have this pension going on for 70, 80 or 90 years. The benefit of it, of course, is that with SMSFs or superannuation, effectively there's no rule against perpetuities for that, so it can just carry on ad infinitum. The dependence, financial dependence, and the tax issue is really crucial for all super funds. By this ability to pay multi-generational pensions is just not available in retail industry funds. So it needs to be specialist SMSF. We talked about the terms, 621, reversionary, simply a person nominated carry on there. As I said, that I won't go into the legislation. And you'll see, I think I've got the regulations here. So these are the SIS regulations. I just wanted to show you a couple of things. So 1.06 talks about all the pensions. So 1.04, 1.06, so it's 1.04 AA. Don't you like, look at that. How ridiculous is this? 1.404 AA, and just carries on. So we've talked about annuities. Remember, that's life insurance companies. And then I want to just show you here, there's some really old, what they call legacy pensions, which really should just be booted out as far as I'm concerned. But we've got here 1.06 meaning a pension. So a benefit is taken to be a pension for the purpose of this Act, and that's really relevant also when it comes around to the tax-free status of income in the superannuation fund for the underlying assets that back that pension. Basically, if it is provided under rules of a super fund that meets the standard of sub-regulation 9A or 1.06A2, which is a lifetime pension, which we generally don't do. You can still do it through a larger super fund, but not through an SMSF, and does not permit the capital supporting the pension to be added to by way of a contribution or rollover. So again, we've just got to be careful about it. We can add a reversion, but we can't add capital to it. So if we want to add capital, we have to roll it back and then recommence it. So if I just go down, I just want to show you this 1.062. And importantly, I'm just going to go through there. So if we have a look here, so this is an old one that was used for reasonable benefit limit purposes. So you don't need to know this. I just want to show you how it works. So the pension cannot be commuted. So that's means to remember that's converting into a lump sum. Except in the following circumstances, so that it goes into another pension, and the commutation is made within 6 months after the commencement day of the pension. Or the commutation is made to the benefit of a reversionary beneficiary on the death of the primary beneficiary. And again, they can pay it out as well. So you can actually start to see that it talks a lot about pensions being commuted. So again, the pension is not able to be transferred to a person other than a reversionary beneficiary on the death of primary beneficiary or another reversionary beneficiary. So transfer simply means it carries on. So as I showed you there, we can have the primary beneficiary going to reversionary, but it also says there in G, and this is contemplated, so this is part of the SIS Act, although we don't pull that in, but it's still part of the law. So it goes from primary beneficiary to reversionary and then to another reversionary. So that's what's contemplated under 1.062G. So that's where we've got this idea of this multi-cascading pensions there. So let's go back here, and as I said, there can be continuous pensions, there can be joint reversionary pension beneficiaries. As I said before, this all comes out of annuity law. And I've just got there, I have seen a client it was a legal client in South Australia, did four pages of terms and conditions. So one of the ones I'm going to put to you is, remember John to Sally, who's the second wife, then to Max and the children. The problem there is Sally, because she can commute and there's nothing left over for the other generation. So if John wants to look after Max and Billy and Bob and maybe Jane, his other daughter, then what we're going to have to do is limit the amount, like a life interest, that Sally can take. So let's just say that Sally can't commute it, remember? So that means she can't convert it into a lump sum at any point in time. She must take the minimum that's required under pension laws, but the maximum, let's say, is going to be 10%. So she can't take a pension any more than 10% of the underlying value of the pension. So for the first year, remember in age 71, Max dies, it goes directly to Sally. She's got $500,000. So we've transferred from an accounting perspective into her accounts through BGL, let's say Simple Super Fund or Class Super. We're off and running. She now is treated, it's now her pension. So for the period of time, it starts for hers to the end of that year, you need to do a minimum pension pro rata payment based on, she was only 50, so it's obviously going to be 4% or 2% now with COVID, and that proportion up to 30 June, but it can't be commuted, and the maximum pension she can have is 10%. Now, if she's the main trustee of the fund and she commutes and takes the money, then what happens there? Then effectively it means Billy and Bob and Max, whoever was the next recipient of the pension, can now effectively, particularly if we put in those non-commutation and those caps and what they can take as an income stream, they can now sue for loss or damages because effectively she's taken it. She's also taken it to defraud both of them effectively, potentially. So potentially there's a jail sentence there as well. So again, we just got to be very careful on that one. The pensions, just a couple of housekeeping matters which are important. Once you turn age 60, even if you're working full time, all you have to do is give up one form of gainful employment. You know, there's tax office rulings, APPA rulings, there's plenty of rulings on that. And then effectively you're deemed to be retired. So what you want to do is always have within your armory the fact that a pension should always commence at age 60. Get a client to go out, even if they go and work part-time for someone for a couple of months and they cease work, then they're going to be retired. Any monies they put in after that by way of a contribution, that's now preserved and needs to meet another condition of release. But all the earlier ones you do. So what you want to do is set that pension up at age 60, and then remember any gains or earnings after that are effectively added to that pension side and they're not part of the T-bar anymore. So it's definitely worthwhile setting up a pension age 60. Dead end estimates have corporate trustee. Again, as I said, just make sure you've got successor directors, so on and so forth. We talked about this, the pension that dies. Have a really good look for those of you who really want to know the ins and outs of pensions. It's about a 30-page ruling, tax ruling 2013/5, when a superannuation income stream commences and ceases. A lot of it is honestly going to depend on what your deed says. Single purpose pensions, rule of thumb, tax-free components go to non-tax dependents or through the estate. Taxable components, just got to be really careful about that one. Pooled investment strategies. So what I mean by that, we've got pensions and we've got accumulation, particularly now we're running maybe 6-member funds. Just have separate investment strategies for the pension side. The reason we do that, if we've got the younger generation doing LRBAs, the outstanding liabilities in the LRBA, if it's pooled investment strategy, will actually spread across the whole of the members of the fund, which will have a T-bar impact on the pension members, but have separate investment strategies. So have one set of investment strategies for your pension and one set for accumulation. Now, if you already hit your T-bar, then there's obviously, you can't segregate for tax purposes, but you can segregate for CIS purposes, which is really crucial, particularly around that T-bar in LRBAs. First reversionary deaths, again, if it just goes from John to Sally, but Sally's not alive, well, we're back right where we started off with. So it just ceases at John. So we need to have, remember, succession. That succession will lead to asset protection, protection from family provisions claims. It also has tax benefits. A lot of it is that financial dependence. And T-bar blow up. Again, if a spouse is already up close to their T-bar and then we're reverting that pension back to the spouse, then we're loading the spouse up. So the only real option there is because the a pension from John if it was Sally, and Sally's already got quite a sizable amount in there. It's okay because she's in accumulation anyway. He can start a pension, but it means she's always going to be in accumulation because her T-bar is already going to be quite sizable, although this instance it's only 500,000. Okay, so these are the questions I'm just going to go in and show you how to build it. So we need to ask who's going to be the reversionary beneficiary. So I would just get these questions and ask your client, just sit there. Who's going to be the reversionary beneficiary? If it's a spouse, that's fine. Is there limitations on them? Who's going to be the reversion beneficiary if they are not alive at the time of the pension member's death? Will there be a second or third reversionary? And will the intermediate reversion beneficiaries take income only without any commutation? Remember that one with Sally I'm going to show you. With a pension member like a clause where any bloodline dependent at the time of the member's death shares jointly in the ongoing reversionary pension. So you can limit it to bloodline only, which is important. What happens if there's no one left? If it goes over to the estate, is it going to be for bloodline only? So you can actually put in there, it can only go to the estate provided the executor makes it for bloodline only. But just to save time, what I want to do is I'm just going to go into our Lightyear Docs site. You can see here I've got the protector open. Next Wednesday, I'd implore all of you, if you've got the time, if not, it'll be recorded from 12:30 next Wednesday. And you'll see that, I'm not sure if it's up on our weekly webinars yet. Let me just see. Okay, so there you go. 12:30 p.m, simple and effective asset protection with the protector. I'm doing a 2-hour training on the protector, showing you exactly what it is, why we're doing every document. We've now enhanced it even further. I've got some really good client communications for you, brand new, hot off the press, plus a video for you to give to your client to show you how the protector works. We've also got Tim Munro, who will be talking a lot about how he deals with it with his clients and what he charges, which is generally between $3,000 to $5,000 per protector. And we'll have Michael Jeffries from Eventum Optimum, who'll talk about how to register mortgages and also PPSR. So if you don't know what the protector is about, make sure you go to that session. And even if you do know what the protector is about, make sure you go to the session and have a look at all the enhancements we've got. Anyway, let me go back and have a look at the documents. So all I'm going to do is just go to the documents, account, oops. I tend to do everything from here. It's just a lot easier. So you can see the current year pension payment, that rollback, if we're trying to add capital, remember, 1.062 doesn't, oh, sorry, 1.061 doesn't allow us to add capital, so we'd have to roll it back. But I'm just going to do an account-based pension. So I'm going to start the document. I'll put it into Abbott test, but it should go into the folder for your client. So I'm just going to go Smith, and then Smith multi-pension. So we're just going to go down there. And you can probably hear my little dogs in the background. They just get so super excited when someone turns up that they like. Then they go into this orgasmic, anyway, weird dogs. Okay, so I'm going through here. And just an aside, look, Lightyear Docs 1, pretty ugly, not the best looking, but it does its job, as you'll see. Lightyear Docs 2 is expected to be released in early November. According to Ashley. So that's super exciting. I'll watch out for that one. I think in the chat room, for those ones you see, Chris, who's my EA, is in the chat room. She's just given you the protector. Chris, can you also put in there your email address and also for the phone number for people to contact you? If you'd like to have, if you're a strategist member, you'd like to have a booking or time with me to go through various issues, just contact Chris. She's the best one for you to do. Okay, so fund member details. So this is pretty easy. Honestly, it's not that difficult to do. Smith Family Super Fund. So what's the full name of the member? John Smith. Now, conditions of release. We can't start a pension until we've done a condition release. So here it's going to be retirement. Now, if we're permanently incapacitated or age 65, we can also start a pension stream. So what's the financial year the account-based pension is being paid in? So we're going to use this year for that. So now it pops a lot of data which we need to complete. What date will the member be making this application? So I'm going to make it, we've got John's coming in next Tuesday. So what I'm going to do is between now and next Tuesday, I'm going to do up the document, send it out to him, draft for review. And then when he comes back, he can give me any review points, but we're going to start it from the 7th, if that makes sense. So his date of birth, I know I go into my system, and at some point in time, these will all be jammed together, or we're going to have all our information. So it'll be very easy to pull up, which will be good. So the 1st of July, 1945. So that should then give me the age of member. He's age 76. So remember, I actually said he was 70. So what I'll do is 1950, 1930, 1951. Okay, 70. So that's fine. You have to put the expected income stream commencement date. So we're going to start. We don't have to pay it at this stage. It can be just a payment towards year end, but we need to know when it's commenced, because that will then determine, as you'll see, the proposed account balance. Remember, we had, in this instance, $500,000. Do you know the exact pension account balance? I'm going to say yes. But if you don't, then what happens is it just simply is to be advised. And that depends on whether you have done the accounts or not. Does that make sense? So you can't get any easier than that. So we've got $500,000 for that. That then determines what the minimum annual pension payment is starting at this present point in time, based on his factors, etc. Now, these are a couple of important ones. If he misses that pension payment, so let's say he only gets $10,000, even if he gets $10,130, then we haven't made our minimum, which then creates a problem, because it means we miss out on the tax-free status of our pension income for the year. So you want to press yes, because what happens there is that if you don't make the minimum, you're a bit short, then that $10 or the $100 or the $1,000 that they've missed out on, there's a promissory note. So the promissory note there is from the trustee of the fund to the member themselves to ensure there's a minimum pension balance. So always tick that one as well. Let's please enter the current year ABP income payment. So we've got to do 10,000. So let's make it 20,000. The tax-free component is 30%. So I click to compute, and that's 70% there. Okay, so that's my base, and that's what most of you do when you go and build other income streams. Now, this is where, not now, we've got to set the trustee up, because there's a member and there's an application form going to the member, then there's a trustee meeting. So we've got our company, Smith, SMSF, nominees, Pty Limited, and then we've got, okay, and then it's 5, Smith Street, Sydney. So last 2000, poor guys locked down. If you're doing this, look, it's preferred to do if you're going to do a pension for a client, the first thing is upgrade the deed, upgrade the company constitution, choose whether you want a leading member or ordinary one, and then build the pension. You should be able to do digital signatures. Wet signatures would be preferred, but let's go digital. So we've got 3 here inside the fund, 3 directors. I've got John Smith. I've then got his wife, Sally Smith. And then I've got another one, which is the son, Max Smith. Now, if I wanted to, I could actually, here's a little thing. Now, you have to press each of these, because these are who's going to sign. So if you don't do that, there is not signature boxes at the end. If I wanted to, I could make Billy and also Bob members of the fund. But they can't be directors, but Max would be their director on their behalf because he's their parent. Okay, oops, Sorry, I don't want to do that. Whoops. So don't lose it for me. Okay, I think I pressed the wrong button. Silly Grant. See what I said? I said stay on the page. I hope I'm not going to lose everything. So stay on the page. No, because I went to the end. Oh dear. Okay, well, see, this is what happens sometimes when Grant does things. So I'm going to have to go back, leave the page. And now I think I've stuffed it up. So, so sorry about that. But I'm just going to show you, this will be actually good because we're going to really build this really quickly. Now, because I haven't saved it, it means it's going to go through. So it's okay. You'll just rip me through. In fact, I'll see if you can predict what I'm doing. So Smith Pension, Abbott-Morley. Okay, fund member details. So the Smith Family Super Fund. So you can see even I make mistakes. What I should have been doing, which I don't tell, is saving answers along the way. Retirement, financial year 21-22, fund member details. We 1st of the 7th, 1951, I think. Yep. Oh, sorry. Right. I could blame those dogs, couldn't I, really? But remember, we're back on the July 1951. I don't want to do that one. It's interesting. You can actually find out what day you were born. So we're going to do on the 7th, age 70. It's going to be starting on the 7th. Do we know? Yes, it's $500,000. Does a member? Yes, we want to do that, which is important. Current year pension payments, we said, were $20,000 and 30%. So it didn't take me long to get there. I compute. I then do the trustee. So again, save the answers. Company there. Smith. Okay, 5. So I'm using my great big fat fingers at the moment. That's exactly why, because my office is under renovation. So I'm actually sitting in my bed at the moment, putting this out. So I'm using my fingers rather than a mouse. And you can see my fingers are quite a way fat. So I'm going to do 2, 3. Confirm. Okay, John Smith. And then Max Smith. Okay, I'm going to click on each of those. So sorry again. Now, again, let me save that. And now we get down to the meat in the sandwich. I'll only be about another 3 or 4 minutes. Okay, reversionary beneficiary. Do you want to nominate a reversionary beneficiary? Yes. So who is the first reversionary beneficiary? It is going to be Sally Smith. Does that follow? Now, so we've got, it's going to go from John and then it's going to go to Sally. Does that make sense? Now, the first question we have to go through, and I'm going to go through this with you. So again, if you're building this, remember, upgrade the deed. So upgrade the company, upgrade the deed, and then go into the pension. So we're going to tick this box. Now, what I've done, I've actually got some words here. So these are up to you. You can amend these words, But what I've got, in the event that Sally Smith remains alive at the time of death, they had to take 100% of my pension in any manner or form they desire as the super laws allow. So that's okay. So she can take the pension, she can commute it. But remember, we've got a problem there. However, so in the event that Sally Smith relates my death, they had to take 100% of my pension with the following conditions. So you can copy exactly this. So the first thing is the pension is non-commutable. So that's okay for the time that Sally owns the pension. So that's the first one. And then the second one is any pension payment must not exceed 10% of the pension account balance. Okay, so does everyone see that one? So what I've done, so that is a really good, strong pension that I know is going to be used for setting up the next reversion. Does that make sense? So the other one that I would use, the original wording that we had there, that's fine if it's just going to go mum and dad. Because I'm dealing with a second spouse, I'm really trying to carry some capital over. So let me just see if there's any questions. So Cliff, will making existing pension to reversionary maintain existing Centrelink grandfathering for seniors healthcare cards? Actually, that's a really good question, Cliff, and being one of my favourite lawyers in the world, I might take that on advisement. So Chris, can you have a look at that question and can you make a note of that? And let's do a bit of research on that one, which would be fantastic. Mitch, can that promissory note be any amount if the minimum is 25 and client forgot to take? Yeah, it can, Mitch. The only problem is that what we need to do is ensure that that promissory note is short term, because otherwise, what it is, if it goes too long, because it's like a check, that it's effectively like a loan to the trustee of the fund. And unlike a UPE, so it's virtually like a UPE with a trust, the problem is that if it's a loan, then we need to then meet the borrowing conditions for SMSF, the custodian trust and all that. So again, we just got to be careful. So that's condition one. Let's go to condition two. So the event of the death of John and Sally, so this is going to secondary reversionary, we need to put in something. Now, I've got a lot here, and I'm just going to read it through. So this is, I built this a while ago. I might change it, and I might start to, what I might do, and if there's a bit of feedback from you, send an email to Chris around that. We might actually start to put some button conditions in there that can make it choose, like the investment strategy ones, so that's a lot easier rather than writing. So here, in the event of my death and the death of Sally Smith, my superannuation pensions go proportionally to each of my bloodline children that remain alive at the time of my death, who may continue the pension or take as a lump sum as the super laws allow. So that would be Max, and also remember the other daughter is June. Now they can't continue the pension because although they're children, they have to take as a lump sum. If June was disabled, she could continue on the pension. Now, if the reversionary pension beneficiary is a child, so with this one, I wouldn't do that one. But let's say any superannuation person go to bloodline grandchildren that remain alive at the time of my death, who may continue pension takes lump sum as the super laws allow. So that's Billy and Bob, for example. Now, if the reversionary pension is a child that's under 25, yes, the pension is to have the following condition: to be paid as a non-commutable pension to age 25, with any drawdown in an income year to be limited to no more than 20%. Let's actually chop that down to 10% of the pension account balance. Any child over the age of 25 must take the pension as a lump sum commutation. Now, I don't need to do that because Billy and Bob are grandchildren. Now, if my bloodline child is not alive, so I don't need to do that. So essentially, if I do that, that's what I could go. But I'm feeling now, having a look at this, it's probably a good idea to actually put in some terms and conditions. But this is a good one. So this will actually go to Billy and Bob, and if June's got some kids, it will go to them as well, and it'll be a proportionate split. So the pensions is to be split as noted proportionately and is to be joint, which means if one dies, it passes over to the other. Okay, so that's the first one. Now the last one. In the event that in the event that there's no one, so there's no Sally, there's no children or anything, then I tick this box, and you should always tick that box anyway. So what have I done here? In the event that neither Sally Smith nor my bloodline children or grandchildren who are my dependents remain alive at the time of my death, my super benefits are to pass to my estate to form part of my super proceeds trust, which is to be primarily for my bloodline. So they, again, it will go over and start in a superannuation proceeds trust. So I'll just save that quickly, and then I'll show you what the I'll then go and show you what the now see, there you go. I should leave the page there. I'll show you what the documentation looks like, answer any questions, and that'll be the session. Again, it's a recording. Sorry, it's gone over time, but when you get into advanced stuff, this isn't just a basic one. What I'll do is I'll also take this, and this will be part of the package that comes out to you later this afternoon. That way you can see the wording of what you get. So we've got account-based pension for the Smith Family Super Fund for John Smith. We've got to have a product disclosure statement. It's stupid. It doesn't matter if you're an accountant or advisor, it's not for you. It's just simply the way the trustee of a self-managed super fund is not excluded from licensing, but so they don't have to be licensed, but they still are required to provide a product disclosure statement where they're dealing with a financial product, hence a pension. So that's what we've got there. So if you've been doing account-based pensions without product disclosure statements, then there's a breach of the Corporations Act, but that's not part of this. So this is the application. So this is the first step. So we've got the deed allows us to build these multi-reversionary, multi-generational pensions, but we have to do it by way of an application. So we've got John Smith, we've got all this, talks about conditions of release of $500,000. As I said, feel free to read through this later on. 7th September 2021, conditional release retirement, 10,000, current year ABP, 30% taxable, 30% tax-free, 70% taxable. So for that one, it's immaterial. For example, it's obviously going to be tax-free to John, and likewise if Sally, Billy and Bob, whoever gets it's always going to be tax-free. But that does apply if it's commuted. So what we've got is a standard one here, and I'm not sure whether I'd like to get your feedback on this. I've put this as a standard term, is that where there's a pension payment over the minimum, so in this instance, it's $10,140 and we've made 20, $9,860 is to be treated as a commutation payment, effectively like a lump sum. And the benefit of that is that essentially it means that that $9,860 will go and be deducted or debited against our T-bar. So if there's other money sitting on that accumulation side, it drops down that T-bar, which is pretty important. And then we've got that promissory note that Mitch was talking about before. The ABP beneficiary is Sally Smith. And then you can see it just happens in the event that Sally Smith remains. All that wording that I had is all sitting there. So I haven't got time to go through, but I want you to have a read of this because it gives you a good standard. I probably will pick up a bit more precedence. I might do a bit more work into it. I'll lean into more of the options there for your ABPs. And then we've got condition 3. And then obviously it's signed. We have 2 witnesses. Generally you only need to have 1 witness, but because it's more of an estate planning play, I'd like to make it a lot stronger and more secure around that one. And then we have the binding trustee resolution. So you can see there, obviously when you've got stuff like that, it means that I didn't put in the address in that. So I'd have to relaunch and go back and do that. Remember, this is in draft anyway, so I'd send it off to the client, or relaunch, send it off to the client, and then come back and make sure it's all okay. So that's exactly the same deal, all happy with that. And then what we do is we sign it off. So although it's a meeting, it's still executed, so it's fairly strong by all the directors. So that's my ABP with advanced estate planning built in there. So Clifford, we're going to have a look at that. Chris Foster, we're limiting the max pension payment cause an issue if Sally lives beyond 90. Not at all. So, okay, so that's a good point, Chris, because you've got to take the minimum there. So that's a really good question. So the way I would do that is I'll just show you how to change it. Oops. So I've got to go back in here. What I would do there, so I can go back in here. I'm not going to do it. I would go into the reversionary beneficiary. Yes. Okay, so it's all dropped off. Okay, so I'll need to go back in here. Go into my vault. I'll just show you what I'll do. Go down, remember Abbott test. And then my last document should be the account-based pension for John Smith, because I finished it. That's why I saved quite a bit, but I prefer just going here anyway. So I'm going to relaunch, and that's a really good question, because Chris is pointing out that once we get over age 90, the PVF factor is up around about 11, I think, or even further. So to cover that, really good. I like that. So in the event that Sally Smith remains alive, they're taken 100%. The pension is non-confidential. Any pension payment must not exceed 10% of the account balance or the minimum pension requirement at that time, whichever is the greater. So that's good. And you can see trustee meeting. That's what I forgot to do. Who attended the meeting? John, Sally, there, select, put that in there, and then I've got select there, and up pops the address. So then I'd finish that. So again, leave the page. So that's perfect. So I would pop that new document, but that covers that issue. Does that make sense, Chris? So that's a really good question on that one. Cliff, promissory note, need to make sure it has a dollar figure. Clearing Hall, gift and loan back, evaluated. Oh, okay. Oh, okay. So that's an important one. Thank you very much for that one, Cliff. And it's great to have my little wingman on that one. So the good thing about the promissory note, there would be a dollar figure because it would be the amount between the minimum, etc. So I might actually fix that up as well for that one. So thank you very much for that one, Cliff. Absolutely perfect. So just going back, make sure that you're on that Protector webinar next week. The upcoming webinars, you'll see there the simple and effective asset protection. I'll be getting you the slides, the PDF of the slides. I'll put in that TR, that tax office ruling. I think it's a really good one. I'll put in this document as well for you as well, and this recording. So that'll be out to you a little bit later on. Again, if you want to, just go in the chat room. If you want to get in touch with, I'll thank you again I'll just take that one. I read a case on healthcare, so I'll go into that one. Thank you very much, Cliff. If you can go to, sorry. Okay. Okay, so everyone's talking about my stuff up. So thank you, everyone. Make sure that if you've got any questions, contact Chris, or you want to book a time with me, just contact her. If you need any work done through Abbott-Family, contact her. But look, hopefully that's given you an idea of what you can really achieve with these account-based pensions. To me, they're from a family provisions claim, they're really, really strong. But anyway, have a look at that. It's Grant Abbott signing off, and we'll see you next week.